Ladies and gentlemen and friends of democracy and freedom, our earlier panelists gave a heartbreaking data on the horrific devastation and trauma that the Russian war against the people of Ukraine has been inflicted. They added to the grim litany of accounts of abductions, deportations, disappearances, kidnapping, rape, torture, and indiscriminate shelling and murder of civilians. It bears repeating that these atrocities are not random acts of individuals. Indeed, rather, they are part of a well-thought-out, systematic, incredibly gruesome attack on the people of Ukraine planned by the Russian elite and executed by the Russian forces. It is clear the powerful symbolism of holding this event today in courtroom 600 of the Nuremberg courthouse, how important we are facing issues. Russia's egregious crimes demand accountability, and with the case of the Nuremberg trials, we must bring the perpetrators to justice. The international community cannot shirk its responsibility in the face of such evil. True justice has to include Russia's leaders, including war criminal Putin himself. Putin was the author of this unjustified, brutal war and must be held accountable for the crime of aggression, which the Nuremberg judgment deemed the, quote, supreme international crime, end of quote. While our focus today is quite rightfully on Ukraine, in light of the recent assassination of Alexei Navalny, Putin must also be accountable for the abuses he has inflicted on oppressing the people of Russia, who want a more open, peaceful, and democratic future for their country. At Nuremberg, the goal was also not just to bring individual leaders to justice, it was also to show the world the horrible crimes the Nazis had committed and create an irrefutable record of them. We must do the same with the Russian perpetrators of genocide, aggression, war crimes, and crimes against humanity in Ukraine. We must pursue accountability with every tool available. We must look forward to a discussion this afternoon of the institutions and organizations, some of them newly created, that are collecting and analyzing evidence and that will be delivering their judgments in due course. Most crimes will be prosecuted in Ukrainian courts, and rightfully so. But international judicial bodies must also play a role, particularly when it comes to Russia's leadership. I think it's also that we should agree on the need for an international tribunal dedicated to prosecuting the crimes of aggression against Ukraine, the people of Ukraine. And I look forward to hearing more about the different options under consideration. We are also anticipating to hear what more individual countries, including the United States, can do to support these efforts. I sincerely believe that we are together working for peace worldwide, which can be achieved by peace through strength, as was championed by Ronald Reagan, to deter war. And we can achieve peace through lawful trial, as evidenced by the Nuremberg trials of perpetrators of atrocities to deter war. At the end of the day, justice must and will be served, first and foremost for the sake of the people of Ukraine, but also for the sake of our collective peace and security and for the sake of our most basic and universal principles. Thank you again for everyone who is present today at this important and historic event, and I look forward to our continued discussion. And we're so grateful to be welcomed to this afternoon in this session by Dr. Christoph Safferling. He is the director of the Nuremberg Academy and professor of criminal law and procedure, and also helped establish the Memoriam Nuremberg trials. And Professor Safferling.
Thank you, Chairman. Once again, dear members of Congress, ladies and gentlemen, it's also, again, a real pleasure for me to welcome you to this afternoon session. I have a quote. When several criminals conspire to commit a murder, every one of them plays a definite part. One works out the plan of murder, another waits in the car, and the third actually fires at the victim. But whatever may be the part played by any individual participant, they are all murders. And any court of law in any country will reject any attempts to assert that the first two should not be considered murderers, since they themselves had not fired the bullet. These words were spoken by Roman Rudenko, the chief counsel for the Soviet Union, in this room on 8 February 1946, when he opened his case. Interesting words. Now, we've been speaking about the crimes, and we've heard of horrible evidence of most heinous atrocities that are being committed as we speak on Ukrainian soil. And this afternoon now, we want to focus on how to prosecute, how to actually hold soldiers, generals, and politicians up to the Kremlin, responsible for these crimes, for the crime of aggression in the first place, but obviously also for the crimes against humanity, the war crime, and potentially genocide. As we learn, being in this very room, and I don't know how you feel about it, but I have the impression that it's extremely fitting that we are having this hearing here in this very courtroom. What we learn from the Nuremberg trial is that an international court or tribunal is never sort of adequately equipped to do justice to all the crimes that have occurred. We need a sort of a separation of the exercise between an international and a national level. And be it the country that is actually affected, like Ukraine, or any other country in the world that can, by virtue of the principle of universality, prosecute, and it should prosecute, because it is the aim in the end to fulfill the promise from Nuremberg to establish a sort of international network of prosecution. Otherwise, we will not achieve at that what we are inclined to do, to have peace under the rule of law. Now, it's my distinguished pleasure that as the director of the International Nuremberg Principles Academy, I can sort of point to the presence of our founders. This institution was founded, first of all, by the Federal Republic of Germany, and we are having representatives of the Foreign Office here and representatives of the Department of Justice in Berlin. I'm very pleased to welcome Dr. Böhm and Dr. Schaal. It was also founded by the city of Nuremberg, and we have heard the Lord Mayor of the city of Nuremberg speaking this morning. And it was finally also founded by the Free State of Bavaria. And indeed, we are in a room that actually is owned by the Free State of Bavaria. And I'm very pleased that one of the representatives of the Department of Justice in Munich is here with us today, Mr. Weinziel. Warm welcome. And I'm saying this because it's my honor now to introduce our Minister of Justice of the Free State of Bavaria, Georg Eisenreich, who has volunteered and agreed to send a video recording, welcome remark, and I'm happy to transfer back to Chairman to hear this recording. Thank you so much, and I hope we all have a good, inspiring afternoon. Thank you.
Professor, thank you very much. And as you recount how important the courtroom was in 1945, 46, and later, actually, it's so inspiring as a German-American myself to recognize the heritage that we have here, the beautiful marble artwork of 1916 that's still in place, and the woodwork of 1916 from the original construction is just awesome, and the symbolism, too, of the beginning, Adam and Eve. And every American of German-American heritage needs to come visit, and that's as they're on their way to Lithuania, so to visit. So, but keeping that in mind, And indeed, we do have, we're so grateful to have a pre-recorded statement from Dr. George Eisenreich and the Minister of Justice of Bavaria.
Dear members of the US Helsinki Commission, dear international guests of the hearing, on behalf of Prime Minister Markus Söder, I would like to extend a warm welcome to you here in Bavaria. The US Helsinki Commission is an important American institution with a long tradition, an important building block of transatlantic relations. It's a great honor for us that you decided to come together here in Nuremberg for this hearing. Today, you are meeting in a historic location. In courtroom 600 of the Nuremberg Palace of Justice, the Nuremberg trials wrote German and international legal history. The Nuremberg trials played a significant role in the investigation and punishment of the terrible Nazi crimes. At the same time, with the recognition of the Nuremberg Principles by the United Nations, they marked the birth of modern international criminal law. And you are coming together at a historical moment. Putin broke international law with his criminal war of aggression against Ukraine. Since then, the world has become a different place. The citizens of Ukraine are defending their homeland, their families, and their freedom in an admirable way. But they are also defending our freedom. They are defending the European peace order, and they are defending our Western values. Putin must not win this war. For this reason, we must continue to support Ukraine with determination, with weapons, with ammunition. We must strengthen Europe's defense readiness. And last but not least, we must intensify transatlantic relations. The West must remain resolute and united. And to come to the specific topic of the hearing, the crimes committed in this war must be dealt with. The terrible war crimes, the killing of innocent civilians must be punished. War criminals must be brought to justice. That is the legacy of the Nuremberg Principles. The criminal responsibility of any person who commits a crime under international law, regardless of whether national law criminalizes the conduct or not. In international criminal law, experience shows that you need a lot of patience, but there is no statute of limitations for war crimes. Putin can be held accountable for the rest of his life. Once again, welcome to Nuremberg. Many thanks to Professor Safferling and all members of the International Nuremberg Principles Academy for their role in the organization of this hearing. I wish you an insightful exchange.
Thank you very much, Minister Eichenrock and Reich, and how incredible, what a wonderful presentation and welcome for the second session. And as we proceed, indeed, I'm going to be repetitious because it's so important, and that is that as an indication of how important it is that we are here, and the issues are so important here, this is bicameral, and that is members of the U.S. House of Representatives, U.S. Senate. That's quite a unique circumstance. Maybe not so unique, but very important here is that it's also bipartisan. Republicans and Democrats are united on behalf of the people of Ukraine. And with that, I'm particularly grateful that we have with us Senator Thom Tillis of North Carolina, representing 12 million very dynamic people of my sister state. And so I'm so grateful for his service. And then Congressman Lloyd Doggett of Texas, just so grateful he represents the capital of Austin. And then, of course, a daughter of Ukraine, now a member of the U.S. Congress, representing Indiana, Victoria Sports. And then we're so grateful, and we need a doctor in the House, and so we do. We have Dr. Andy Harris of Maryland. And with that, each will be giving opening statements. And of course, we begin with Senator Tillis.
Thank you, Mr. Chair. I'm going to be very brief so that we can get to the witness testimony and hopefully as many rounds as possible in the time provided. I thought that this morning's session was very important. I just want to go back and prove that as we go through this process, prove to the world that democratic nations are better. Democratic nations are committed to the rule of law. Democratic nations are committed to due process. Everything that Vladimir Putin doesn't represent. He's not only guilty of crimes in Ukraine, he's guilty of crimes in North Africa. He's guilty of crimes in his own country. He has victimized untold millions of people in Russia. So for the purposes of this hearing, we want to hear more about what we can do to hold ourselves to the high standards of Western democracies. We want to demonstrate that we can be cool-headed in the face of passions. We could find many opportunities to move quickly, presuming guilt, but we have to presume innocence until they're proven guilty. And everything that we do, every page of evidence, every photograph, every lead, to be corroborated, to be ready to be put before our justice system so that justice will be served and will be served expeditiously. Thank you, Mr. Chair.
Thank you very much, Senator Tillis, and we now proceed to Congressman Lloyd Doggett.
Thank you, Mr. Chairman. In the past 2 years, we've seen the largest ground invasion since World War II here in Europe. It threatens our shared values of freedom, democracy, and the rule of law. The Russian military at times has seemed to be more interested in targeting Ukrainian civilians than targeting the Ukrainian military. It's conducted a war of terror, whether attacking kindergartens or nursing homes, hospitals or apartment buildings as their residents slept. Putin has decimated critical infrastructure designed to plunge civilians into darkness and frigid temperatures during the cold weeks of winter. And what Ukrainian grain he has not stolen, he has attempted to destroy. To ensure accountability, Europe, the United States, and other liberal democracies around the world must pursue multiple forms of justice. The wrongdoing is so broad that there is no one panacea nor one path forward to achieving justice. Procedural justice, retributive justice, and reparations for the extensive damage that he has caused. I fully support the efforts of the ICC and its investigation of Russian war crimes and domestic investigations in countries such as the UK, Lithuania, Germany, Sweden, and Ukraine itself. I'm also very supportive of establishing a special tribunal on the crime of aggression in Ukraine. What the judgment from this very courtroom in 1946 noted as the supreme international crime, because it certainly is. None of this would have occurred but for the crime of aggression against Ukraine in the first place. Such a tribunal could potentially create a precedent that prevents rogue governments from launching a war of aggression in the future and punish the authoritarian leaders who attempt to evade fundamental human rights obligations and observe the law of armed conflict. While supportive of all of these various initiatives, we cannot wait for a hypothetical future date for justice. Ukrainians have suffered enough in 2 years, and they continue to suffer from these grotesque attacks. Justice must be sought soon at every opportunity. From the beginning of this war, I have pursued a set of countermeasures to put pressure on Russian government in form of sanctions. The morning after the invasion, filing legislation which eventually passed and was signed into law, but has proven to be most inadequate. As Putin's atrocities have continued, I support additional congressional action to provide billions in immediate aid and to continue to tighten sanctions. We should long ago have been providing fighter planes and air defense systems for Ukraine. But now the time is for the United States House to follow with bipartisan leadership that the Senate has already provided. Talk here today is fine. We're united in support of Ukraine, but it is action that will save lives. Now is the moment in which We need to say no to the appeasement caucus within the House, as we have said no to appeasement around the world, and to seek immediate assistance that is complete, that is focused not just on the military needs of Ukraine, but the humanitarian needs of Ukraine, and funding for continued research and investigation of war crimes and bringing these children back home. While timely delivery of military assistance is the most urgent priority, all aspects of this need to be achieved. I believe that President Zelensky was so right in saying that this is really a battle between freedom and fear. Now is not the time to yield to aggression or lose resolve. Now is not the time to talk about defeatism, except in terms of defeating Russian aggression. We must redouble our efforts and pursue all forms of justice, certainly looking to a future in which there are not only criminal penalties, but civil justice. We need to assure that Russia contributes significantly to the rebuilding of Ukraine and the damage that it has caused. Those responsible should be held liable criminally, but compensation should be available for the many who have suffered so much. I look forward to the testimony, the comments of this next panel with such diverse expertise from around the world, and I know we will benefit from it as we return to Washington to put our words into action by getting this assistance to Ukraine, not tomorrow, but immediately. I yield back.
Thank you very much, Congressman Doggett. We now proceed to Congresswoman Victoria Spartz.
Thank you, Mr. Chairman. It's sometimes when I sit in this room, so I'm really thinking about, God really made some things not by accident, but God usually gives us challenges when He knows we can succeed and step up to these challenges. And Ukrainian people went through so much suffering through centuries, but it developed Ukrainian people and strong, freedom-loving people that unfortunately sometimes it takes to die for freedom, but willing to die for freedoms. That's what America was founded on, where freedom-loving Americans, founding fathers of our country, were willing to die and fight for freedoms. That's what built strong nations and republics, that the fight is willing to fight for the rule of law and the equality of rights. And it's kind of a little bit interesting. I was actually point out earlier in our discussion, I mentioned Roman, who was born in town of Nosivka in Chernihiv region, Ukraine. And actually one of the staff the executives here point out to, and I was born in the same town of Nosivka, Chernihiv region, Ukraine, but actually Roman Rudenko, prosecutor general who was part of this Nuremberg trial, he also was born in the town of Nosivka, Chernihiv region of Ukraine, which is really in some ways maybe ironic, maybe meant by God. And I truly believe God always has a plan, and God always on the right side of history. And He knows what is evil, what is good. And God will always stand with the people that willing to fight for freedoms and willing to protect rights. And I think that is something very important for us to remember. But I also think, the challenges that Ukraine is going through right now, this is the challenges of us as a society that believe in these values. And we have to prevail and help Ukraine to succeed, because it will empower a lot of people around the world that suffering from evil, from dictatorships and tyrannical regimes. And I think if we don't succeed, there is no hope for the rest of the world. And we need to keep people strong and win these big battles. And I truly believe with a lot of smart, strong people and a lot of great Americans that did a lot, but I think, for freedoms around the world and continue doing that, and also Europeans, who actually went through a lot of sufferings to stepping up in defense of this, I think we're going to prevail, because ultimately, if good cannot prevail, that why we even been in these positions, why we even doing what we're doing. But it's interesting, that never thought in the wildest dream that I will be sitting here and this time representing, great and very strong freedom-loving people in the state of Indiana, strong fighters for freedom. And I truly believe we have a wonderful freedom-loving state, and we're kind of heartland of America. Some people actually call us flyover state, but I actually think, I would encourage you to come and see our state, because this is really heart of America. This is what the values of America and fundamentals and foundational principle of our country. And I'm very honored to represent people in the United States Congress, but also help to fight for these freedoms around the world. But thank you for doing this today. Thank you.
Thank you very much, Congresswoman. Indeed, it can't be restated enough. Born in the USSR, a daughter of Ukraine, now a member of the U.S. Congress. If you ever wonder about the American dream being alive and well, yes, it is. And another example of American dream indeed is Dr. Andy Harris of Maryland.
Thank you very much, Mr. Chairman. And I want to once again thank you for holding this second hearing of the Helsinki Commission outside the United States. Again, as I mentioned this morning, the first one held in Gdansk for the prevention and deterrence of Russian aggression. And unfortunately, we need a follow-up hearing today to now deal with the result of that aggression. As has been suggested, we need action on violations of international human law and the recognition and punishment of war crimes to act as another means of deterrence for such future aggressions. You mentioned the Adam and Eve symbolism on the wall here above us to the left and right. We have the scales of justice and we have the hourglass of time. And time is certainly important in this case, as we have to, as ongoing aggression and violation of international law continue to occur on a daily basis, as we are reminded of this morning. And it's our duty to do whatever we can as the Helsinki Commission, part of the OSCE, to help the international community deal with this, again, in a timely and fair fashion, so that we don't see repeats of this in the future, of this kind of war crimes, violation of international human law, and aggression. And with that, I'm very interested in hearing from this afternoon's panel, and I yield back.
Thank you very much, Dr. Harris. And we're so appreciative of the panel that will be coming next, and they can be seated, and that would be first the Prosecutor General of Ukraine, Andrei Kostin. Andrei was appointed to his post in 2022. Prior to that, he served as a member of the Rada, the Parliament of Ukraine. He is an attorney in private practice before his government service. And General, thank you so much for being here. And then Gabiya Gutadze, and we're so grateful. Today, we have the Deputy Minister of Justice of the Republic of Lithuania, and all of us in America would like to point out that in 1940, the United States never recognized the occupation of Lithuania, and then the people of Lithuania never wavered that one day they would be free and liberated, and gosh, are they free and liberated today. So we're so grateful that you're here. And the Deputy Minister started her professional career as a legal advisor to the National Parliament of Lithuania, and then became legal advisor to the President of Lithuania. And then we're grateful to welcome back for his 5th time Professor Safferling, and as director of the Nuremberg Academy, and with so many other duties, Professor of Criminal Law and Procedure. And so we'll begin again with presentations from each of you at 5 minutes, and then we will have a panel. We will then have questions from members of the House and Senate, and I'm confident that we would have time for 2 rounds. With that, we now proceed to General Kostin.
Thank you, dear Chairman Wilson, respectful members of Commission, distinguished panelists and audience. February 24th will mark 2 years of Russia's unprovoked and unjustified full-scale aggression against Ukraine. It's a flagrant violation of the UN Charter's prohibition of the use of force against the territorial integrity and sovereignty of a state. As we speak, Russia continues ruthless attacks against cities and residential areas, indiscriminately targeting Ukrainian civilians inside and outside of the occupied territories. Russia does not shy away from the commission of widespread and systematic atrocities that amount to crime of genocide, crimes against humanity and war crimes. Russia started this unjustified war as a part of a policy of persecution, the goals of which Putin recently reminded us: to deny Ukraine its statehood and identity. We all know that this criminal regime will not stop until it is stopped. Right now, Moscow believes that they can break the unity of the allies who support Ukraine, and they act with renewed impunity. Throughout Russia's war of aggression, we have been fighting for just peace, freedom, and sovereignty, while remaining committed to the rule-based international order that Russia seeks to undermine. That's why we seek justice through an intrinsic web of accountability, as the legacy of a Nuremberg tribunal so clearly defined, I quote, "Crimes against international law are committed by men, not by abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced." End of quote. The long arm of justice must reach first and foremost for those who possess themselves of great power, the masterminds who set in motion the machinery of evil. This legacy has evolved over time into a multi-tiered system encompassing ad hoc international and hybrid tribunals, national courts, and the International Criminal Court, which share the common aim to end impunity for international crimes. Ukraine recognizes that we have a primary obligation to end impunity for the more serious crimes of concern, while ensuring cooperation and partnership with international and national stakeholders. We are investigating and prosecuting international crimes committed by Russia in parallel to executing the defense of our nation on the battlefield. My office has registered over 122,000 incidents of war crimes, identified 508 suspects, and convicted 80 perpetrators so far. This year, our investigations will focus on the criminal elite, those who plan, command, organize, and execute international crimes. We have already indicted 9 Russian generals, but we need to hold the leadership of Russia's criminal regime to account for the supreme international crime, the act of aggression. My office has opened an investigation into this crime, but the national justice system is procedurally barred from prosecuting such officials in domestic courts due to their personal immunity. I'm speaking about so-called troika. The gap in accountability needs to be properly addressed. The establishment of a special tribunal for the crime of aggression is the way forward. An increasing number of states support this initiative, and rightly so. For the past year, the core group of 40 states have been working on the architecture of special tribunal. By our understanding, the special tribunal must be international in nature to overcome jurisdictional barriers, focusing on the manifest case of the act of aggression that followed the annexation of parts of our territory. We hope to see the special tribunal offer proactive justice rather than be a passive court in waiting. The International Center for the Prosecution of the Crime of Aggression was established in July of last year, a crucial first step to facilitate investigation and case building against the crime of aggression. Currently, the ICPA team is composed of Ukrainian, Lithuanian, Latvian, Estonian, Polish, and Romanian prosecutors. We are pleased that the United States also seconded a special prosecutor, Jessica Kim, to our team. The legal appraisal of Russia's actions on the international level in parallel to national prosecutions in Ukraine will ensure complementary actions that bring justice for all victims and survivors. The failure to bring this international prosecution would signal a return to the era before the UN Charter, undermining the legacy of Nuremberg. It would be a powerful signal from the international community that other regimes can follow Russia's steps. Important layer of accountability is the sanctions regime, encompassing individuals and entities including financial institutions, banks, oligarchs, proxies, and organized armed groups closely tied to the aggressor. Sanctions undertaken by singular states and institutions can and do in practice act as an accountability mechanism, and they erode the ability of Russia and its enablers to wage this war. Stricter enforcement will cut deeper. We value efforts undertaken by US and hope to see an increase in sectoral sanctions, export restrictions on companies producing drones purchased by Russia, and the targeting of financial institutions that facilitate military purchases. As you can see, it's a complex and multi-layer web of accountability for Russia's crime of aggression. Being here, it reminds me of emotional words of the last surviving Nuremberg prosecutor, our dear friend Benjamin Ferenc, on Russian invasion of Ukraine. I'm heartbroken to see it happening again. Kids being shot, homes being blown up. He taught us to never give up, as we have no other choice. In 2022, he gifted me a book narrating Nuremberg judgment, and by that, passing the baton to succeed in holding aggressors and war criminals accountable. And I'm glad that Benjamin witnessed continuation of his life's work with issuance of arrest warrant against Russia's President Putin before passing away in April 2023. United, with the determination and resilience, we will succeed. Thank you.
Thank you very much, General Kostin. And now we proceed to Dr. Greta Yarta.
Good afternoon. Members of the Helsinki Commission, colleagues, dear all. First, I would like to express my gratitude for the Commission and Academy for organizing this event in that historical place, and I'm truly honored to be invited here to share my thoughts on accountability of Russia for aggression against Ukraine. Today, after a couple of introductory remarks, I will present 4 very concrete lessons from Nuremberg that, in my belief, must be taken into account in order to serve Ukraine with justice. Mr. Chairman, I was also born in Soviet Union, in occupied Lithuania. And when I was 7 years old, Lithuania restored its independence. During 50 years of occupation, Lithuania lost 1/3 of its population due to war and repression, as well as emigration and deportation. But if you read the Russian textbooks on international law or history, you would get told that no aggression against Baltic states happened, that those states were never occupied, and that the Soviet Union never committed atrocity crimes under international law. And this false historic and legal narrative, including the denial of Soviet international crimes, relies on the Nuremberg judgment. So at this stage, I arrived to the first lesson of Nuremberg. In 1945, the Soviet Union got away. So the lesson we must learn is that legal arrangements which accommodated political preferences of the time, that is, avoiding escalation after Second World War at the price of compromising full legitimacy and full justice, have devastating consequences for the peace in the future. Nazism as evil was condemned in Nuremberg, but Soviet imperial thinking was never put to trial. And this could only embolden Russia of today to constantly challenge borders, sovereignty, and independence of bordering countries. Nuremberg is an example how history can be manipulated through the legal process if the legal process is not done in the right way. Wherefore, with the establishment of a tribunal for the crime of aggression against Ukraine, we have to make sure that we leave no space for political manipulations and impunity and condemn the imperial ideology of Russia. Because this imperial ideology behind Russia's aggression against Ukraine gives this aggression its distinct character, which together with its gravity and scale makes this aggression one that is in manifest violation of the UN Charter. The second lesson of Nuremberg is that concrete persons and not abstract entities, as also prosecutor mentioned, like states, are responsible for waging wars. And the crime against peace, which we now call the crime of aggression, is the supreme crime, the source of evil, because this crime is followed by widespread and systematic war crimes. And that is why trial for the crime of aggression must be as central as possible, because only if criminal responsibility for the root cause and not only for the consequences is ensured, the credibility of the rule of the non-use of force can be restored and strong deterrent precedent can be set. The third lesson of Nuremberg rests on the need to emphatically reject the paradox that the legal responsibility is the least where power is the greatest. Where powerful national leaders, leaders of the permanent members of the UN Security Council, offend fundamental international legal rules, they can be pushed to the margins of political power only through the work of effective international justice. Nuremberg opened a new era in that it established and enforced the responsibility of those having the greatest power. The Special Tribunal for the Crime of Aggression against Ukraine provides the world with the chance to also open the new era, the era in which the golden seat in the UN Security Council does not entail impunity. We want to believe that the law should protect victims of Russia's aggression, and at the same time, we take it that the most responsible are protected more by power than by law. They are not. And wherefore, the most principled and effective way for ensuring accountability for the crime of aggression against Ukraine is a fully fledged international criminal tribunal established on the basis of an international treaty concluded between the United Nations and Ukraine. The possibility of the UN General Assembly to be involved in the establishment of the tribunal is also being questioned. Without going deep into legal deliberations, I will directly turn to the last lesson from Nuremberg. Robert Jackson, the chief prosecutor of the United States, said at that time that unless we are prepared to abandon every principle of growth for international law, we cannot deny that our own day has its right to institute customs and conclude agreements that will themselves become sources of a newer and strengthened international law. This statement, made by a great US lawyer, must resonate with all of us today, when an ideal solution for the establishment of a special tribunal for the crime of aggression against Ukraine simply doesn't exist. In 2010, US Ambassador for Global Criminal Justice, Beth Van Schaak, wrote that the adoption of the crime of aggression amendments in Kampala presents the indelible shift in the balance between power and law in contemporary international relations. Today, we stand at the crossroad of power and law. To forego a truly international tribunal and instead to go for a hybrid tribunal within the judicial system of Ukraine would be worse than just playing with time. It would also mean playing with all hopes and prayers for justice of the Ukrainian people. This is so for the reason that a hybrid tribunal would automatically take Putin with his entourage off the accountability table. Concluding my statement today, I feel like reiterating the words of Stefan Zweig, that it seems like a rule of history that contemporary people seldom recognize the important characters and events that shape their times. An aggression trial is vitally important for the historical truth established by law. And now, as we see a momentum on the crime of aggression for the first time since Nuremberg, we, contemporaries, must seize the moment and recognize that our call is to shape not only our time, but also a peaceful future for our children. That is why we must confront the task before us with a sense of urgency, and as the task for the international community as a whole, not the task for Ukraine, Eastern Europe, or Europe. And if the fear of victory is still holding us back, I wish that every one of us does things that one is afraid of, because this is the only way for growing and for being stronger. And I, as an international legal scholar working in politics, I honestly believe that international law can be different and can be stronger after Russia's aggression against Ukraine. And today, The choice is upon all of us. All is needed is courage, political wisdom, and will to make it happen. Thank you, and I will be glad to answer your questions.
Thank you very much, Deputy Minister of Justice for Lithuania. You reflect so well on your country, and we're just so grateful to have you here. And then, of course, we're so grateful to be with Professor Seffering, to be here at the Nuremberg Academy. Professor.
Thank you, Chairman Wilson, Senator, dear members of Congress. First of all, obviously, I'm just an inadequate substitute for the person who is actually supposed to be here, which is the Federal Public Prosecutor of the Federal Republic of Germany. As a matter of fact, he was summoned to Berlin yesterday, so he can't be with us here today. And, well, I volunteered to jump in. Now, I'm not a practitioner of international criminal law, but I'm a scholar of international criminal law, and I've sort of studied Germany's role in prosecuting quite extensively. So I'm slightly positive that I can, do justice and answer your questions with regard to national prosecution of international crimes, in particular with regard also to Ukraine. Now, what I can tell you is the history of a state that has struggled for quite some time with international criminal law. I can tell you the story of a nation of perpetrators. It took for Germany really quite some years to appreciate the positive effects of the Nuremberg trial. That we are in this courtroom here today, and this event being sponsored by the Federal Republic of Germany, is by no means logical and natural, but is the outcome of a long history, the history since 1945. So the positive aspects of the Nuremberg trials were, first of all, that the guilty were identified and convicted. Secondly, that some justice was done to victims, even if the victims did not play that much of a role in the Nuremberg trial. The third very important aspect, and this is an aspect that is important for any trial in the international agenda, is to establish the truth. We would not know as much about National Socialism as we do now had it not been for the Nuremberg trials securing and documenting all the evidence. And a fourth aspect that was extremely important for the Federal Republic of Germany and the founding narratives, even if only after decades that became apparent, is that the Nuremberg trial delegitimized National Socialism. So today in Germany, we have a code of international crimes that was only adopted in 2002 after the Rome Statute, or just before the Rome Statute entered into force. And it was established in order to fulfill the obligations under the complementarity principle, to show that Germany is willing and able to prosecute international crimes. Until then, Germany had ratified the Genocide Convention, and it had introduced genocide as a crime into the criminal code in 1954. It had also criminalized the crime of aggression, but only as late as 1968, even if there was the obligation to criminalize aggression in the Constitution, which was adopted in 1949 in the German Grundgesetz. There was no war crime concept, there were no crimes against humanity in the German criminal code. So only in 2002 that was, the law was amended and the Code of International Crimes was adopted. And by the way, Whitney Harris, a former Nuremberg prosecutor, was present on the visitors gallery in Berlin when the Bundestag decided and adopted the Code of International Crimes. This code foresees the universality principle and thus the competence of the Federal Public Prosecutor to investigate and prosecute any situation anywhere in the world without a genuine link to Germany. Now, as of today, the German courts have heard cases against 69 accused ever since 2015, 69 accused, 22 of them were female, It investigated 11 situations. The accused came from 14 different nationalities. 25 of the accused actually were German nationals. And the cases were heard before 10 different upper regional courts and the High Court of Justice. We have 9 cases of crime against humanity, 3 cases of genocide, the rest cases prosecuting war crimes. Now, the crime of aggression was introduced into the Code of International Crimes after the Kampala Compromise in 2017. The crime is now a leadership crime, as in the Rome Statute. The universality principle has been amended. Now, a genuine link to Germany is needed to prosecute the crime of aggression. One major issue, of course, in domestic jurisdiction, and the General Prosecutor has alluded to that, are immunities. For the crime of aggression, as a leadership crime, personal immunity will be respected for the leadership troika, head of state, head of government, foreign minister, but only as long as they are in office. With regard to functional immunities, the Federal Court of Justice has ruled on January 29, 2021, in a case against a member of the Afghan armed forces that concerning international crimes, no functional immunity would apply for an agent of a state. In a lengthy and well-reasoned judgment, the federal judges pointed to customary international law that originated here in this courtroom. And shortly after that, as you know, the Upper Regional Court in Koblenz convicted 2 members of the Syrian Secret Forces, Syrian Secret Service, for torture and as crime against humanity. Now, let me maybe conclude with a personal note. Now, being the director of the International Nuremberg Principles Academy, and I've been a member of the Advisory Council for some time, we are organizing a moot court here in Nuremberg for students, and we have done so for almost 10 years. And for many, many years, we have a growing number of teams from Ukrainian universities participating in this moot court. And I've met so many fully engaged young people from Ukraine who were ready and willing to believe in the rule of law, and they did a great job in this courtroom. As much as I can remember, until 2021, they always made it to the semifinals. One team from Ukraine always made it to the semifinals, some years even to the finals. And I'm deeply devastated that these, the positive image of these people and the positive attitude is under such a distress ever since the heinous attack of the Russian Federation. But it's my strong belief that Ukraine is a great people with great students who believe in the rule of law and who are willing and ready to do the right thing and prosecute war crimes, crimes against humanity, and genocide. Thank you so much.
Thank you very much, Professor, and indeed thank each of you for your presentation. We'll now proceed with each member of the Senate and House proceeding with strictly enforced 5 minutes, and we're really grateful that we've got proper timing, hopefully soon. And Dr. Gregte Dayerba, I have had the fortunate opportunity, having been an election observer in Bulgaria in 1990, to see Bulgaria become such a dynamic country in a post-communist era. And I've visited, indeed, Lithuania and Latvia and Estonia to see what dynamic Baltic republics are. And what, in your post-communist development, what advice would you have to General Kostin?
Thank you for your question. I have very good advice that if you delay justice, it is very difficult to pursue justice afterwards, because Lithuania started criminal investigations into international crimes being committed on the territory of Lithuania after many, many years, because, we were occupied, and our independent prosecutorial institutions, as soon as we, established our independence, we immediately understood that this is of the essence to do, that is to have justice for the things that were done in occupied Lithuania. And of course, evidence collection after that many years, people, they naturally die, and, testimonies, they vanish, and people don't remember because memories, they fade away. And for us, it was a big challenge because even though we started quite a lot of criminal cases, we succeeded only in a few of them. So the main advice that I have is to do justice now and not later.
Well, it's so important that we learn from each other, and we can. In fact, I'm looking forward this weekend on Friday, welcoming the ambassador from Bulgaria to visit the U.S. presidential primary on Saturday in South Carolina. And I can't wait to take him from polling location to polling location, as I had the opportunity to visit polling locations in Bulgaria, June 10, 1990, before you were born. So, but it's, again, we learn from each other. That's why I wanted to ask that particular question. And General, is what can we do more to back up your efforts in terms of the capabilities of, indeed, through social media, whatever, to assist you? And I want you to restate again the website of, as people have information to whom, how it can be provided, because that's real world.
Thank you. Thank you for for your very strong and principled position in support of Ukrainian people and in support of our justice and accountability endeavors, which we truly implement not only for Ukraine and for Ukrainians, but for all of us, for all civilized world, all those who share the same values of democracy and freedom and rule of law. I think what we will need substantial support for our accountability endeavors for years. Because the previous experience shows that even when we are documenting and prosecuting war crimes in times of war, but it will last for years, maybe for decades, as previous experience says to us. So I think that support of our accountability endeavors, we will need international experts, we will need support in capacity building of our prosecutors. We have young and very devoted prosecutors of war crimes department and specialized units which we create on sexual violence, on environmental crimes, which we first prosecute, on cyber crimes as war crimes, which we first prosecute in the world. So this, we need to be sure that your support will be sustainable and will be for years. This is extremely important, because otherwise justice will be delayed.
And I'm just confident, in a sad way, as war criminal Putin continues, the assassination of Navalny, the support of the regime in Tehran, the collusion with the Chinese Communist Party, every day it becomes clearer there's a connection. And a final point, Deputy Minister, I want to mention, you're welcome to come to my office, 1436 Longworth House Office Building. I can prove that Lithuania was occupied. I was at GUM department store and bought a package, it was a tray of the Soviet republics in 1990 at the department store, and of course there was a badge of Lithuania and the other two Baltic republics, and at that time it was really mystifying to me they would be selling this, because you were already an independent country that day, and on that same day Armenia withdrew. But I have a tray of the badges, and when they told me it was 5 kopecks, I said, great, I'd like the pink, the blue one and the green one. They said, no, the whole tray. So it was obvious they didn't know the cost of production. Aside from that, now we proceed indeed to Senator Tillis.
Thank you, Mr. Chairman. Thank you again for being here. I know that this is a solemn and serious hearing, but I have to admit, Doctor, that you have the most difficult name that I've ever been confronted with pronouncing. And so for that reason, I'm going to refer to you as Vice Minister. But thank you for being here. I should have said it this morning. But we need to start, as oftentimes we forget to distinguish between what I believe is a pathological liar and serial killer in Vladimir Putin and the Russian people. For all the atrocities that we can talk about in the past, more recently in Ukraine, there are untold atrocities that have occurred today. The most recent, probably just this week, with Mr. Navalny, who understood the truth of the Russian totalitarians and through his courage communicated that truth and unfortunately lost his life. So for any Russian who may watch these proceedings or see us move forward, I think it's important for us to distinguish between people who probably desire freedom, they've never experienced it, and the leaders who I think are murderers and, excuse me, serial killers, who systematically, over the course of history, have systematically occupied and tortured and killed millions of people. I do also agree, Mr. Costin, that justice delayed is justice denied. And we talked earlier about how we can strike the balance between speed and fairness. And I think that the testimony that we have heard today is evidence of our mutual commitment to that. I guess I'd like to go back to the discussion this morning, though. We talked about resources. I think you mentioned Palantir as the platform that you're using to track this information. I'm going to get more into systematic, sort of the foundational elements of the program. To what extent do we have professional audits and compliance? And I'm digging to the next layer. We were talking about earlier today about capturing evidence, authenticating it, corroborating it, all the things that are very important. But how do we ensure that all of these practices, beyond the words that were spoken today, what sorts of practices are being put in place today so that any skeptics could have their questions answered quickly about the integrity of the processes, the controls that are in place, the auditability of these processes? Could you speak to that, please?
Yes, first of all, it's a very important question, because when we started after the beginning of full-scale invasion, of course, it was challenging. And when we have so many war crimes committed at the same time, we need to allocate resources, we need to train people, we need to organize our work. And it was very important for us not only to address these issues immediately, but also to think about how to organize it on strategic level. That's why, together with our partners and friends and experts, and together with NGOs, civil society organizations, who are working with us, and there is a special platform in my office, more than 40 NGOs and civil society who help us to document, investigate, and prosecute war crimes, work with our prosecutors and investigate. And it's very important. So we prepared this strategy of investigation and prosecution of international crimes, where we formalized how we inter alia, how we prioritize cases, because we can't investigate all of them simultaneously. None of the countries can do it. This is important to understand. So we also created specific methodology for our prosecutors who are dealing with prosecution war crimes on central level, and we created 9 departments on regional levels to the territories close to the battlefield and close to the active places of hostilities, and specific methodology in order to ensure unified practice. We need fair trial, therefore we need specific quality and standards. We start to interact very actively with not only with the experts from different countries, but also with the International Criminal Court, because their international standards are of the highest level. And we need, as I always say to my prosecutors, when you document the case, you don't know where this case will go, to national system or to the international. So this is a little trick for them, but for them to be very careful that any case could be lifted to the level of International Criminal Court, or this evidence could be used at the International Tribunal. And on the other side, the most important for me that we work for victims and survivors. They need to be properly cared. That's why we created the special instrument, the Coordination Center for Victims and Survivors, people who are specially trained to work as a bridge between law enforcement system and victims and survivors to ensure the all comprehensive support to survivors, not only legal, but also psychological, moral, and others, in order for survivors to understand that we work for them, because justice is served, justice is delivered for the victims and survivors. This is extremely important because they are those who suffered from this war.
Thank you.
So all of these elements, together with the modern technologies and artificial intelligence which we use, all together ensure that we will do it not only in expedite way, but also do it in a very strategically formed basis, and will do it in line with high standards.
Thank you. My time has expired, but in the next round, I intend to come to Professor and Vice Minister. Thank you, Mr. Chair.
Thank you so much. And indeed, we're so fortunate to have Senator Tillis here. And we're fortunate to have Congressman Lloyd Doggett, too, Congressman.
Thank you, Mr. Chairman. I'll just ask my questions generally and invite any of you to respond. Regarding prompt action on a tribunal to deal with the crime of aggression, I suppose action through the General Assembly is one path. Is action through the Council of Europe another?
If you allow, potentially yes. So we have already enlarged partial agreement to establish the register of damage, the civil part of our web of accountability to ensure reparation and compensation. So we have already established a platform how it could be done, while we need first to understand if Council of Europe is ready, because the other option is just to sign an international agreement of the countries who support the creation of tribunal, and then to establish it like it was established for Nuremberg, without UN, without any other instrument, without Council of Europe. So it's potentially also possible. The international law gives us a lot of opportunities, while we all understand that the results of such tribunal should be widely internationally credible. That's why the idea to engage UN is, of course, one of the best options. While we are not also forgetting about the idea of another international organization to be used as a platform, and the international agreement at all, if a lot of countries will be on board.
Do you have thoughts on that, Vice Minister?
So, you know, when 3 lawyers get in one room, we can get as many models as politicians would like to have on the table. Because, you know, the core group, I myself, I participate in the core group representing Lithuania, and what I can say is that, you know, sometimes lawyers, they discuss on the things and they don't see the end result in the end, you know, so they get in these discussions, and we perfectly understand that we have good model that could provide full international legitimacy, could be feasible, but most importantly would be the strong precedent for the future. And you, Chairman, were referring to the strong deterrent message. So if we want to send strong deterrent message for the nowadays dictators and future ones, we have to make a very strong and legitimate precedent. So now coming directly to the question being asked, you know, international law has changed a lot from the times of Nuremberg. We have major developments within human rights. We have major developments within practice of UN in establishing tribunals, in bringing back, you know, international peace and security, in dealing with threats to continuing threats to international peace and security. So, of course, as General Prosecutor was referring, Council of Europe mandate in establishing possibility for the Council of Europe to establish tribunal is also there, but of course we understand that we have to question ourselves on the mandate of Council of Europe, on the mission that it had, and compare it with the mission that United Nations had, with its establishment, with the faith that countries had while establishing the United Nations, while having the practice of international criminal tribunals. So I think it's more about not whether it could, you can create many things, lawyers, they are creative creatures, as I say, so, they will always think out the solution, but the thing is, if we care about legitimacy, we have to remember that we have institutions that can still restore international, faith in international legal law in general.
Professor, do you want to add?
Of course, I have a third view, if you want to hear a third view of a jurist. I'm wondering actually whether we need to decide what the forum could be to try the crime of aggression now. And I'll tell you why. Looking back at the Nuremberg precedent, in 1943, November 1943, the Allied powers decided actually in Moscow, in the so-called Moscow Declaration, on the political will to prosecute German war criminals, also for the crime of aggression. But they didn't establish a charter for a tribunal. They issued the political will to do so after the end of the war. So then, after the defeating of Germany on 8th of May 1945, then in July 45, they sat down and discussed on how they're going to do this. So I'm wondering, and now it is important to express the political will unequivocally. We are going to prosecute the crime of aggression. And we have the ICC. We have an arrest warrant. So there are two things that we can do now. First of all, politically to express this will, and secondly, to establish the mechanisms that we have to be in a position to actually prosecute the crime of aggression. Maybe not for this case, but in the future. So they equip the ICC with, the force to actually also prosecute the crime of aggression, and maybe leave the question on how we're going to deal with Vladimir Putin and the crime of aggression for the time when the war is over. Because what could be worse than establishing a mechanism now, which then, after the war has ended, and we actually have them, doesn't fit and doesn't have the legitimate basis that it could have if we were to sort of prepared to then, create a fitting solution. Thank you.
Thank you, Mr. Chairman.
Thank you very much, Congressman Delegate. We now proceed to Congresswoman Victoria Sparks.
Thank you, Mr. Chairman. And since Senator challenged me, and as a lower house, People's House, we always have to stand, for the challenge of the House of Lords. I actually, Dr. Grigori de Girde, I have a question for you, and I will actually try to pronounce your name. I apologize if it's, not correct, but actually, probably not just my Ukrainian heritage. According to Ancestry.com, sort of my heritage is actually Baltic and Scandinavian, probably from the all of the times of Vikings, so that makes me even more feisty. I have to step to the challenge. But the challenge and the question I actually have for you, what do you think from your perspective, what would be the potential pitfalls? We need to think of them and how we can be more proactive, when we go through this process.
That is a good question, because I think all of us understand that you can go to the UN General Assembly resolution only once. So that means that before you do that, you have to be quite sure that you succeed. And you succeed in the legitimacy that you want to have. So usually, in that discussion, we start discussing on the numbers. So what could be considered as being legitimate? So how many states have to say yes? 40, 50, there are different numbers that can be said. But so I think answering to your question is that I think it is very important to have very clear roadmap how we do it and how we find ourselves in the General Assembly. What I mean by this is that sometimes, you know, as I have quite a lot of bilateral meetings with different, you know, politicians coming from other countries, and sometimes I sort of hear, you know, that this country is, you know, is against international tribunal, or they, you know, would go with a hybrid one. But in the discussion, I find out that it's on the opposite. Because I think that there is a lot of explanatory work that still has to be done. Because there is still too much countries that have made political decision to stay neutral on this modus operandi level. That means we all agree, because it's very easy to condemn, you know, Putin, to condemn crime of aggression, but it's far more difficult to make sure that accountability is there. And that is why I also take it as my mission, because every time I try to explain what legitimacy, what international legitimacy means, because I think that to make this tribunal legitimate is harder than to make it legal, because we can have, you know, Council of Europe, we can have multilateral treaty, it will be legal. But it would never be legitimate, because we need to have cross-regional support. We need to have as much countries being aware of what they are doing and how they confront this task that I was referring in my statement. So I think that we need a very clear roadmap, and I think all these numbers, you know, how many votes we are going to get, I think it's more about speculation that actually thrives maybe to discourage Ukraine a little bit more, saying, you know, that let's wait what happens in the battlefield, and then we see what happens, you know, in the legal battlefield. But, you know, I think that we, you know, Western, as you mentioned in your statement, Western democracies, we make, we look at the battlefield and then we make political decisions. For Putin is the opposite way around. First, he makes very clear political decisions, and then he looks how they are being, you know, implemented in the battlefield. So I think that clear roadmap, you know, talking with countries, explaining, you know, the importance of the task that we still have to do. And I think in the end, in the General Assembly, each state has one vote. You know, whether it is big or small, it's one vote each. So I think nobody wants to see themselves on the screen being, you know, in red light on the resolution for the tribunal.
Okay, thank you. In 20 seconds, I have left Professor Sarperlin, if you want to add something.
Well, how could I add to the wisdom of the Vice President, the Vice Minister of Lithuania? No, I agree in wide parts. You know, I think there are so many options, and we have to be really clear what can we achieve and what would be indeed legitimate. I think about legitimacy and acceptability. You know, that's very, very important in this very sensitive area. And who knows? I mean, the war is over, and maybe Russia would agree in the Security Council to have a tribunal. You know, we don't know that yet. Could be, because political situation could be totally different.
Okay,
thank you.
Thank you very much, Congressman Sparks. We now proceed to Congressman Dr. Andy Harris.
Thank you very much, Mr. Chairman. First, I guess a kind of technical question. It looks like you can divide war crimes into two categories. There's the crime of aggression, and then there's kind of all the rest, because the rest actually are prosecutable by the ICC, or the crime of aggression is not. So how do you define a crime of aggression, and why do I ask that? Because the other crimes are kind of downstream. Upstream is the crime of aggression. I guess it's crossing an international border for the purpose of conducting violence. But it's not always clear-cut. For instance, Mr. Putin would say, well, Ukraine is not really an international boundary because Ukraine is all part of a greater Russia. In our civil war, we crossed what became, at that time, an international boundary. The southern states seceded. We crossed it. Was that a war of aggression? When Israel goes into Gaza, is that a war of aggression? It's a functional international boundary. So how do you define war of aggression? Or is the beauty in the eyes of the beholder? I mean, is it how one person views this and how do we objectify it? And then the follow-up to that is, if you can't perfectly objectify it, how do you prosecute it in a court? And I think the deputy minister kind of alluded to that a little bit, because ultimately maybe the only court is the court of public opinion. In that, if you can't, for instance, come to a consensus on what tribunal is going to hear this, and you form a tribunal, but it's not a consensus tribunal, because, for instance, if the Security Council had anything to say about it, it certainly Russia would not allow it. But the purpose being merely to show it to the world, and ultimately the court of public opinion is a universal court, especially in the digital age. So those two issues. How do you define a war of aggression? And then how do you successfully, in a legitimate way, prosecute it in the absence of a consensus?
I will start, if you allow. I think that, first of all, there are really a set of different definitions in the international law. I think one of the most modern is in the Rome Statute, and this is as a matter of fact recognized and ratified by more than 120 countries in the world. So we can apply to this definition. And it includes, of course, attacks and invasion on the territory of the other country, which has internationally recognized borders. And the Ukraine has internationally recognized borders when become independent in 1991, recognized also by Russian Federation by set of even bilateral agreements between Russian Federation and Ukraine. I'm not even talking about recognition of international borders of Ukraine on the level of United Nations, all international organizations, etc. So it looks like Russia recognized the international borders of Ukraine for like 20 plus years, and then thought that, okay, Crimea was sometimes a Soviet Union, in Soviet Union times was, so this discussion is absolutely useless, because from being independent in 1991 and being recognized as an independent state within its borders, there is no discussion about internationally recognized borders of Ukraine. And attack and invasion is an act of aggression. But I want to add, what is really different from many other situations historically, and what is the same with the Nazis Germany, Nazis regime. The difference is that Russia did not only attack, did not only invade with intention to annex, but Russia annexed the territory occupied by Russia in Ukraine. And first act of annexation was 2014 Crimea. Second act of annexation was just before full-scale invasion, the Ukrainian part of territory of Ukrainian Donbass. And third act of annexation was in 2022, these fake referendums. So Russia did not only attack, they really attack with intention to take over the territory and add it to Russia. And this is very important distinction between Russia aggression against Ukraine and many other historical situations. But it is completely the same, like Germany did during Nazi time in relation to the other countries which it occupied.
Thank you, Mr. Chair.
Thank you very much, Congressman Harrison. We now will do a second round, but it will be somewhat abbreviated in that we can't wait to get to Ambassador Beth Van Schaack. So with that, and in lieu of a question, I just want to, again, thank each of you and then reiterate something that our person ahead of the curve, our senator here, Tom Tillis, when he mentioned, again, we're not against the people of Russia. And as I mentioned, I had visited Chelyabinsk as the sister city of my home community of Columbia, South Carolina. I was in Novosibirsk one time and pleasantly surprised to see a billboard greeting us saying, "Welcome to Novosibirsk, the Chicago of Siberia." I had wonderful visits to Moscow. I had wonderful visits to St. Petersburg. I had an intern in my office from St. Petersburg. With Congressman Madeleine Badayo of Guam, we placed a wreath at the world's largest open cemetery, the victims of the siege of Leningrad, and it was in the shape of the flower arrangement in the shape of the United States red, white, and blue flowers to show our appreciation of the people of Russia. And then I found out that the reason that there was success against Hitler at Leningrad is that the equipment was lend-leased from the United States. And so we had a direct role there to protect the people of Russia. And then our appreciation of the people of China is different from the Chinese Communist Party. Personally, my dad served in the Flying Tigers, 14th Air Force in Kunming, Chengdu, and Xi'an. I grew up with a deep appreciation of the people of China. And so our opposition to the axis of dictators is not personal. And then with Iran, I have a very significant Iranian-American community. They're just so positive and we put aside the drone attacks that have occurred against Saudi Arabia, against United Arab Emirates, against the United States, providing IEDs to kill American troops across Iraq and Afghanistan. And even today, the arming of the puppets of Hamas and Houthi and Hezbollah to attack Israel, but not just that, but in the Red Sea, even today, underwater drone attacks, can you imagine, because of Iran. So over and over again, we're not talking about the people of Russia, or people of China, or people of Iran, but we're talking about the dictatorships that oppress them first, and then they come up after others. With that, I yield to Senator Tillis.
Thank you, Mr. Chairman. Thanks again to the panelists. I've spent most of my career in business, not in public service, and the bulk of that professional career was in establishing methods and practices, and that's what's instructed my questions. I feel like we have a lot of work to do here. There's no question that there will be compelling evidence that a crime was committed and that some number of people need to be held accountable. But I do think that we need to work now to come up with a credible framework that's not episodic, that's not just focused on what's going on in Ukraine, because this evil has existed for thousands of years, and we've never really had, I think, a standing body where we can clearly go to. And the reason why I think we need to create something that will withstand the test of time, to be omnipresent, at least among democratic nations, is because I think it could have a deterrent effect. You know, we could be talking about a tribunal for a lot of the atrocities committed, again, by Putin and his regime in North Africa. So the work to get this right, ostensibly to focus on the crimes that are being committed in Ukraine, I think is vitally important. But I also think it will be very, very difficult to gain consensus. And you're not going to gain consensus among all nations, all members of the UN, but at least a sufficient number to make it legitimate. Vice Minister, Professor, do you agree with that? And you have any suggestions on how we get started? Because I don't believe that we've gotten started on that critical piece of a method or a foundation going forward. If you disagree, please disagree.
I don't want to disagree with you, but I want just to remind you of the fact that there is this International Court of Justice case, arrest warrant, that spoke about, that we have different types of tribunals. We have international ones that can lift personal immunities. And the interesting fact is that at that time, when ICJ delivered its decision, International Criminal Court, that was called the one that can actually lift these personal immunities, had around 50 members, if I am not mistaken. I don't remember exact number, but it was around 50. So that means that if the court thought at that time that membership of 50 countries is enough sort of to name it as international and as legitimate, that would be able to lift immunities. So maybe it also, offers some guidelines on the numbers. But I totally agree with you that we have to have a credible framework because, I don't think that we have luxury to create some mechanism that Putin would only have possibility to mock at, saying that, look, we have ICC arrest warrant, I am still in Kremlin. Look, we have tribunal for the crime of aggression, I am still in Kremlin. So the thing is that, we Lithuanians, we perfectly understand the historical responsibility that is upon us, and we definitely don't want this threat, for our security, also for the international peace to continue. And I think the only way to undermine legitimacy, I agree, that not all Russians are serial killers, but you have to also take into account that imperial thinking is also within Russian society very deeply rooted. So it's not that you call it, serial killers or not, but we have to understand that this society has been raised by the imperial thinking with maps of a huge, Mother Russia in every classroom, where actually Baltic states are also in this big family of Russian walls. So
Professor.
that's my short comment.
History books are an important weapon. That's just a side remark. Yes, we don't have a common strategic sort of approach, as a matter of fact, and that's certainly sort of something that we should develop. I don't have an idea how this is going to materialize. We have Eurojust within the European Union that has sort of taken up some sort of leadership with regard to coordinating prosecution of international crimes within those states that are, amongst states that are willing within the European Union to do so. But it's only sort of first step. We need a much, broader, more strengthful approach to have a strategic sort of prosecutorial approach. The ICC is not in a position, as it seems, to take leadership on that. Maybe it's not even willing to do so. But it should be part of this overall sort of concept, where you definitely need to work towards developing it.
Thank you. Thank you all again.
Thank you very much, Senator. We now proceed to Congressman Lloyd Doggett.
Thank you. While our focus this afternoon has appropriately been on what was termed in this room in 1945 as the supreme international crime, that of aggression, I'd like to ask you a little about the impact of that aggression in dollars and cents. We know the destruction of homes and businesses, the destruction of lives. I felt that we should be taking Russian sovereign assets to pay for that. Our colleague in the House, Michael McCall, has legislation, the Repo Act, to do that I support, that has been approved in committee. I proposed a more narrow measure to at least get at the profits from those sovereign assets. I'd like your reaction to how we get compensation for the terrible losses that the aggression has caused.
Thank you. Definitely obtaining compensation and reparation for everyone who suffered from this war, for Ukrainians who suffered, and for Ukraine as a state, for local communities, for businesses, for any who lost his or her private property. I think it's about also restoring justice, and that's why it's one of the key elements of our web of accountability, the civil one. We completely support the Repo Act because we believe that it's not only about legal model, but it's also about delivering justice in time. Delivering justice in time of war, because the money which could be used to compensate damage for Ukraine and for Ukrainians will definitely support their fight for, or our fight for our land and our fight for justice. I believe that, the estimation of the World Bank of the last year were about $400 billion US. We still have no estimation, more fresh one, We believe that this figure could be doubled, yes, at least. And it's very difficult for us to estimate the losses on the occupied territories for which we have no access. So we can only try to trace this like from satellite or from other sources, but it will be not proper estimation. We also count the potential loss to our ecology, to our environment. And for that, we have a specific high-level working group which prepared so-called environmental compact, because the assessment of environmental damage in course of war was never done before. No one did it. And of course, we can't use only our methodology, Ukrainian. We want this to be credible on international. So when time comes for Russia to compensate damage for our environment, we will have a credible figure, supported by everyone who will be in charge of international compensation mechanism, as we say, as a key element of the International Compensation Commission. The authority which will take decision whom and how much to pay from Russian sources. Of course, the number of Russian sovereign assets is not enough to cover everything. But I think that the position, once again, the political position, the brave courageous political position to take action now will give lawyers an opportunity to decide how to do it properly. This is once again, about the tribunal. Politicians should instruct lawyers how they want tribunal to be set up, not the other way around, which we have in the situation with tribunal, because it's about political courage to say, yes, we want Putin to be at the dock, and then lawyers will do their job.
And I believe your office has recently included an environmental crimes section that you work on. Can you describe what those crimes have been? The environmental crimes, can you describe them more fully?
Yes, we have a set of crimes, so it's not only intentional pollution and destruction of our soil, of our forests, of our rivers, water, so it's not only contamination of this. We are also investigating attacks on nuclear facilities, and not only Zaporizhia nuclear power plant, the biggest one in Europe. So my colleague already gave you some insights on this. We have also investigation on the occupation of Chernobyl nuclear power station. And the latest case we have moved forward is the attacks on Kharkiv neutron facilities, so the nuclear reactor in the scientific facility in Kharkiv, of which Russians are quite aware of where it's located because it was built during Soviet Union times. It was attacked 74 times from March to September 2022 by different types of weapons. And according to our investigation, the attacks were concentrated exactly on the building with the nuclear reactor and with the warehouse where the nuclear materials were stored. And we have identified 3 generals and 2 colonels who were behind these attacks. And it's very important to note, one of these generals was also with Russian forces in Syria. So his impunity for crimes committed in Syria led possibility for him to commit crimes against Ukraine. And of course, the blow-up of Kakhovka Dam, the biggest environmental catastrophe on the territory of Ukraine after Chernobyl station. So these are only the elements of the environmental crimes which we investigate. There is also discussion on potential adding of the crime of ecocide to the Rome Statute as 5th international crime, which will take some time. But even at the moment, the International Criminal Court is looking very carefully and very attentively in the possibility to investigate long-term, widespread and severe consequences to environment, one of the war crimes which is prescribed into the Rome Statute. ICC never did it before, and we communicate with them. We work in partnership in order to put those who commit this crime to account.
Thank you for your leadership.
And thank you, Congressman Doggett. Congresswoman Victoria Spartz.
Yeah, Mr. Chairman, I think it's a very valid discussions. We actually had some legislation by parties in last Congress dealing with International Criminal Court, and there is a lot of politics in that too, and it was actually very difficult, but we're able to expand some of the enforcement on war crimes domestically in the United States, and we were able to pass some legislation. So I think that would be a valid discussion to have framework and roadmap how to deal with that, and not just maybe Ukraine is just the beginning of that process, but how we can have on consistent basis. But I kind of wanted to follow up, as someone who is really, more into like weapons. My question is, because I understand, unfortunately, you have to be very well equipped with weapons if you want to deter any wars, especially with aggressive countries, how important they are. What are your thought processes in using, Russian sovereign assets to pay for weapons supplies to Ukraine? From a legal scholar perspective, to use it as a payment for, for providing weapons to Ukraine. I don't know if you have some sort of professor first and, from a perspective of scholar.
I don't think I understood the question. Could you rephrase
So
it?
using Russian sovereign assets to pay for supplying weapons to Ukraine from a scholar perspective, what are your thoughts on that?
That's a very tough one.
We can ask a woman if we have to. She will answer the question.
I won't coy away, but I mean, the financial situation in Europe and in Germany is obviously very difficult. And from the very beginning onwards, I didn't quite understand the system. First of all, when, the Russian Federation attacked then mainland Ukraine, February 22. All of a sudden, the international community said, oh, now we have to impose sanctions. And I was wondering, so what actually did you do when the Crimea was sort of under attack and then incorporated into Russian Federation, whatever that was? Didn't you impose sanctions then? So, what are you doing now? What are the next level? And then every other month, they were imposing real sanctions, and now the real sanctions. I mean, where do we stand? Obviously, they don't work, and we haven't even started to impose
But it
proper
is
sanctions.
fair to say we have a lot of loopholes in sanctions too, and exemptions, which really the most, allow Russia to avoid them, and really in the industry that the most important where Russia makes a lot of money, they're exempt for one or another reasons, and that is also a big problem. In enforcement of sanctions, we don't have a proper mechanism, so I think they would really work very powerful if they would be enforced as they should be.
Yeah, no, absolutely. These need to be enforced, and I mean, we have legislation in place in Germany, obviously, to sort of prosecute, investigate these criminals who sort of circumvent the embargo and have deals and do contracting with Russian companies. But obviously, the system is flawed. It's not strong enough. So I would certainly sort of press for harder sanctions and for imposing and actually then insisting on the imposition of these sanctions.
Maybe Prosecutor General and Dr. Grigado Dagurdek, maybe you'll have 30 seconds each too, so I'm not over my time.
First of all, of course, it's your decision, because the legal theory behind the Repo Act as a matter of counteraction, so it's clear for me, and of course, I don't see any, of course, I'm not the US citizen and not your politician, but I don't see any obstacles in using of the funds for any type of support. So this is my position. I don't see any obstacles. I think it's more about political decision on the level of Congress. While I fully agree that we have a lot of loopholes in sanctions regime, but never before in world history the world was so united, imposing more and more sanctions. So, of course, if we see something to be improved, we need just to improve. We don't need to discuss it along.
Right. Okay. Doctor.
Just a short comment. When we talk about, reparations, that is directly related to the state responsibility. And then we can question, the legal ways how we can confiscate the sovereign assets. But I would like to draw your attention to the fact that European Union has recently worked on the directive, the aim of which is to have horizontal framework, legal, how we deal with the sanctions evasion, because there were member states that still didn't have any form of legal responsibility for the way like businesses and people behave trying to evade sanctions. I also want to share Lithuanian best practice. What we did, we created special fund that all the money that we collect from the fines and financial fines that are being imposed on the legal entities, we collect into the fund so that we can delegate it automatically for the Ukraine. And the very last comment that I also hear sometimes from politicians that we can't finance the war with these assets, frozen assets, because then we don't have finances for rebuilding Ukraine. But then I have this very question. So, but if you don't finance the war, you might have nothing to rebuild.
That's right.
So this is, the logical mistake that some politicians also make.
Thank you.
Thank you very much, Congresswoman Swartz. We now will be concluding with Dr. Andy Harris.
Thank you very much. And just following up on what I asked previously, it looks like in terms of tribunals, there's no perfect solution because we will not have a consensus. I mean, there's no way you're going to get every country in the world to agree. They can't agree on the ICC doesn't include every country. The ICJ certainly doesn't include every country. So the question is, and again, reminding, the hourglass with the wings, I mean, time flies. Is it time to just go ahead and create a group of nations, and the G7 doesn't work, the G20 doesn't work for a variety of reasons, the G12, the G15, who are going to decide that there has to be a tribunal for prosecution of war crimes. I guess the question is, one, first of all, is that what we ought to do? Let's just go ahead and get going with something. Second is, should it be a view to an ad hoc, where it's just going to deal with Ukraine and Russia, or should it be the model for going forward so that there's a venue for, because that's not the only place in the world where violence and crossing of international borders occurs or will occur. So your thoughts on those two issues, and Vice Minister, and then the other two?
So thank you for the question. I will start from the first question on G20, G30 or whatever. I think the main risk that we should manage is that if we talk now about JIT, prosecution into the crime of aggression and International Center for the Prosecution of the Crime of Aggression, we have to understand that it has been established on the prosecutorial efforts by countries that were former being occupied by Soviet Union also. So if we talk about legitimacy, so then we have these countries that start prosecution into the crime of aggression. Then these countries, they decide to establish tribunal for Putin. It would be lovely if Vilnius gets, also this honor to have such tribunal also. Because then if we talk about and discuss legitimacy, would it be seen as legitimate from the perspective of the rest of the world that sort of this Eastern, European region decided to establish its own tribunal for Putin? Because then we have a very good precedent, for African countries, and then we have different systems of, legal legitimacy, different system of human rights standards, and then I don't know whether we want that international law development in the end. So I think that with international cooperation with the United States, also in the JIT, the aim is to increase legitimacy of the prosecutorial effort also. That means that countries, they do support this, I can say now, regional prosecutorial effort into the crime of aggression so that it is seen as legitimate, having the same fairness standards with the verification of evidence collection and preservation, so that later on these evidences, they are not challenged in the tribunal and the truth is not undermined by that. And the second question was whether we have this ad hoc tribunal. Yes, we need the tribunal that will fill the legal gap, and the very clear, narrow legal gap, that is the crime of aggression, because all the other international crimes will be covered by the ICC when Ukrainian domestic jurisdiction is not unable or unwilling, or the other national jurisdictions like Lithuania on the basis of universal jurisdiction can also do that, convictions for other international crimes, but we don't have legal mechanism for the crime of aggression, and that is very, very narrow gap, and with very, very limited number of people. Around 20, I don't know how many you count, and maybe you have already made the list.
Yeah, first of all, we need to have an ad hoc judicial mechanism for our case. This, I think, will be the most exact answer, because on the one hand, the ICC has also jurisdiction on the crime of aggression, but not in our case, because for legal, I would say, reasons. While in order to ensure full accountability on international level, I think the ICC in the future will become the proper instrument. We need, once again, after lessons learned, we need to improve some elements of the Rome Statute in order to ensure that crime of aggression could be prosecuted in case the aggressor will start it in the other situation and in the other parts of the world. But for Ukraine, we need a special mechanism, and I don't think that actually if JIT member states, just once again, what is joint investigation team was created by initiative of Lithuania, Poland and Ukraine in March 2022, and then Latvia, Estonia, Romania, Slovakia and Romania joined, so 7 countries. The ICC actually is partner of the JIT. The Eurojust is the coordination authority of this JIT, and we have also memorandum of understanding with Department of Justice of United States. So United States is also a partner of this JIT. So we understand that even if the JIT will be the only countries who support the creation of tribunal, I hardly believe that JIT will be left alone, because many other states who believe that justice should be served, justice should be delivered for the victims of the crime of aggression will also join this tribunal. But we want to do it in the right way at the moment. At the moment, there are 40+ states which support the idea of tribunal. And I will let you know one very important thing. We started to talk about tribunal to fill in the gap in accountability in March 2022, first month of our invasion of Russia against Ukraine, while first official support of the tribunal appeared only in October 2022. And I will give you the fact why it happened. Before that, it was very substantial discussion, legal and political, but no one stepped in officially. After first massive attack of Ukrainian critical civil infrastructure on 10th of October 2022, when several power stations, water supply stations were destroyed, first countries of JIT member states, they officially said, yes, we are for tribunal. And then the others follow, and now we have 40+.
Thank you.
Thank you very much, Congressman Harris. As we conclude this panel, to me, again, it's inspiring to see such capable and competent people as we really face the issues of holding Russia accountable for war crimes, and we learn from the lessons of Nuremberg. Thank you each, and Godspeed, General. Thank you. We now will be proceeding to our second panel, and it's very fitting that we have with us tonight, or this afternoon, the Ambassador, Beth Van Schaack. Ambassador Van Schaack was sworn in by the U.S. Ambassador at Large for Global Criminal Justice 2022. In this role, she advises the Secretary of State and other department leadership on issues related to the prevention of and response to atrocity crimes, including war crimes, crimes against humanity, something so important that we see today, kidnapping, Russification, genocide. Thank you so much for being here today, and we look forward to your presentation.
Well, thank you so much to the Helsinki Commission and the Nuremberg Academy for holding this really important conversation today. It's really an honor to be back here in courtroom 600 to be able to offer some closing reflections on a really rich and insightful conversation. Today, as we discuss the atrocities taking place as part of Russia's full-scale invasion of Ukraine and what we can do more collectively to ensure comprehensive victim-centered justice for the people of Ukraine, I too am really struck by the power of place. Many have eloquently commented upon where we're all sitting here today, and so I just want to offer this quick perspective. When generations past took on the immense challenge of investigating and prosecuting war criminals in these very rooms, they had very limited practice to draw upon, let alone established international law or institutions that today make up the current ecosystem of international justice. As we heard earlier today we are now fortunate to have stronger legal and institutional frameworks, as well as much improved documentation capacities, including when it comes to open source information. And we also have networks of collaboration that can be harnessed to pursue justice. The principal challenge now is not to chart an entirely new path, although there are some areas where we're going to need new or evolved solutions to defend the UN Charter and deliver justice in the context of this terrible war. Our task now is to best utilize the expertise, resources, and networks of international and national investigators and prosecutors to ensure that there is comprehensive accountability for Russia's brutal war of aggression and all of the war crimes and crimes against humanity that Russia has unleashed on the people of Ukraine. To this end, in my job and as representing the United States, we are dedicated to enabling and strengthening 5 pathways to justice for Ukraine in coordination with our colleagues in Ukraine and also partners around the world. We see these paths as complementary and mutually reinforcing. So, pathway number 1, we know that the main engine of justice will be the courts of Ukraine, and thank you so much to the Prosecutor General Kostin for all of his leadership and for sharing his perspective here. The United States is committed to assisting Ukraine's institutions as they work to document, investigate, prioritize, and prosecute war crimes. Prosecutor General mentioned the Atrocity Crimes Advisory Group that my office has been funding. This is a joint US, UK, EU initiative to provide coordinated, timely, multidisciplinary training, consultation, and strategic guidance. We're also supporting a number of other key institutions in Ukraine, including the National Police, which are in charge of investigations, as well as a number of civil society actors to build capacity for atrocity crimes investigations, ensure victim-centered justice, and provide long-term assistance to survivors. And I want to thank Congress for providing really focused funding to be able to support justice and accountability in this way. The second pathway runs through international institutions, and a number of them have been mentioned today. The United States is supporting the work of the ICC and its investigation into the situation of Ukraine. In addition, there's the Commission of Inquiry established by the United Nations, the UN Human Rights Monitoring Mission. We've heard today from Professor Bilkova about the important work of the Moscow mechanism through the OSCE, and the UN Special Representative on the U.S. Special Representative of the Secretary General of the United Nations on sexual violence and conflict. The work of other international bodies, like the Register of Damage being stood up within the auspices of the Council of Europe, will be critical to understand the full impact of Russia's war of aggression and eventually ensure reparations to victims, to enable them to reestablish their life paths. The United States was very proud to become a founding associate member of this body when it was established in May. Pathway number 3 is aimed at supporting and coordinating investigations at the national level in Europe and elsewhere. One of the ways this has been done is to deepen the United States partnership with Eurojust in The Hague. Almost immediately after Russia initiated its full-scale invasion, national prosecutorial authorities across Europe within Eurojust banded together to coordinate strategies, share information, and potential evidence. And as Professor Safferling noted, they're able to use extraordinary forms and extraterritorial forms of jurisdiction, including universal jurisdiction. This is a collective effort that will enable them to coordinate their actions across the various courts. They've formed a joint investigative team, as we've heard, particularly with the neighboring states of Ukraine, and they've also created a core international crimes evidence database. We're very proud, as the United States, to be able to support this effort, which has been a catalyst for advancing cases anywhere that perpetrators may be found in the world. The fourth pathway runs through courts here in the United States, and this is where the work of Congress has been really central. At the end of 2022, Congress amended the War Crimes Act to be able to expand jurisdiction and enable U.S. courts to assert jurisdiction over individuals who have committed war crimes who are present here in the United States. That will enable us to be a partner with our European colleagues who all have this prosecutorial authority. At the end of 2023, you will have seen the Department of Justice filed its first ever case against 4 Russia-affiliated military personnel. The charges include torture, inhuman treatment, and unlawful confinement of a U.S. national in Ukraine. We're extremely hopeful that Congress will continue to plug gaps within our prosecutorial authorities and within the U.S. legal framework, including by enabling our Department of Justice to charge perpetrators with crimes against humanity. This was one of the core crimes prosecuted right here in this room, alongside war crimes and crimes against the peace. We do not have that authority. Almost all of our NATO allies do, as well as a number of other states around the world. These are crimes that can be committed when they're part of a widespread or a systematic attack against a civilian population. Now, pathway number 5, as was alluded to by a number of you, are the negotiations to create a special tribunal for the crime of aggression. The United States is participating in those negotiations through the core group. We remain very actively engaged. We're meeting monthly with the idea to create a legitimate and a powerful tribunal that will be able to prosecute the crime of aggression. We're also contributing to, as those negotiations are ongoing, the work of the Center, the International Center for the Prosecution of the Crime of Aggression, also stood up in The Hague to advance the eventual prosecutions. These are prosecutors working together to identify information that may become evidence, to establish the chain of command. We've heard mention of the fact that this is a leadership crime, and so who are those individuals who should be prosecuted for the crime of aggression? The Department of Justice has appointed an experienced federal prosecutor, Jessica Kim, to serve as our special prosecutor. We are very pleased, with help from my office, to be able to contribute $1 million to the International Center to allow these prosecutors to work together. In our collective pursuit of comprehensive justice for the people of Ukraine, we should be realistic about the fact that prosecutions will take years. This is a multi-generational effort, and not all victims of atrocities will have their day in court. This is why Ukraine should start at some point thinking about what transitional justice look like, to include other forms of justice, rehabilitative justice, truth-telling, and memorialization initiatives. And this is one of the contributions that the Nuremberg Academy has been able to make around the world. In conclusion, these 5 pathways are very much part of the legacy of Nuremberg. Just as the Allies at the end of World War II advanced the imperative of justice and ushered in a new era of accountability for the worst imaginable crimes, it now falls to all of us to ensure that the promise of Nuremberg and the precious Nuremberg principles are not mere history. So far, the international community has stepped up. We have seen an immense coordinated commitment by states around the world and international and Ukrainian civil society, national legislatures, justice architectures, policymakers, to build out this new integrated system of international justice. And I'm quite proud that at this critical moment in history, the United States is again playing a leadership role, just as it did after World War II in this very room. Timely and impactful legislation from you, from Congress, has enabled us and been instrumental to us to be able to support the work of the International Criminal Court, the work of Eurojust, the International Center for the Prosecution of Aggression, and to strengthen our own legal authorities. These crimes committed by Russia have been devastating, but our resolve to bring these atrocities to light and to hold those responsible are as strong as ever. Thank you all for being a part of this effort, and thank you for allowing me to be a part of this conversation.
Thank you very much, and we'll now proceed to questions, and I will begin. And I just want to thank you for your passion and what you're doing and what you're serving. The environment you're in concerns me, and that we need your judgment on the international institutions. You mentioned so many that indeed are positive, that can be counted on for integrity, but the United Nations itself, with the Security Council, the capability of veto by 2 of its members of anything to me that might be constructive, but even worse, in Gaza, the collaboration of UN personnel with the Iran puppets of Hamas, and the collaboration into terrorist attacks within Israel, but then to find out a control center or communication center for Hamas, Iran puppets, was located, virtually co-located with UN operations. How can that be addressed?
Thank you so much, Chairman Wilson. There's no question that the United Nations has not served its purpose here when it comes to all of the various conflicts that you've mentioned that we've talked about over the course of the day today. It is very much in part a function of the fact that the then Soviet Union was one of the victorious allies. It was given a permanent position on the Security Council, and with that comes the privilege of being able to exercise the veto, which, as we've seen over the many years, including going back to Syria, when it vetoed the referral resolution to the ICC, it has used to block accountability and to block responsibility for its own actions and for those of its proxies and partners, and as the term you used, its puppets. So this has given rise to proposals for institutional reform, but they are very much at the hands of the permanent members of the Security Council.
Well, and indeed, the level of travesty is that the Russian Federation is one of the Security Council members, the actually war criminal Putin himself. With that in mind, too, with the assassination of Alexei Navalny, do you have any ability to look into this as to what international organizations can take actions to raise a response to what has just been such a clear assassination?
Yeah. Indeed, that's a tragedy, and we may never know exactly what happened on that day that he died, but we do know that Putin killed him. One way or the other. This was at least the third attempt that we've seen over the years. He was a spokesperson for free thinkers, not only in Russia, but across the world. And he paid an enormous price for that. I think you can eliminate the man, but you cannot eliminate the message. And we've seen now with protests across the globe how what he had to say with respect to free speech and anti-corruption has really resonated across the world. Now, to your question, which is, are there concrete things that can be done? Obviously, we need to continue to understand what happened that day so that we can shine a light on it, try and get that body back to his family so he can be given a proper burial, but also so that examinations can be done from a forensic perspective to see whether or not he was again subjected to poisoning or some other form of, what other form of malign action was responsible for his death. It is very difficult to do human rights work within Russia. That has been one of the legacies of Putin. He has crushed human rights, civil society. And so many of these groups now have to operate extraterritorially, but they are still doing so with great courage. And there are still individuals within Russia who are trying to document human rights abuses in defense of the Russian people. And so that work has to continue. And that's, again, a place where Congress can be quite helpful by funding and capacitating that work.
And his wife Yulia is such a inspiration. I hope in whatever way you can help back her up. And then a final question. We've just got to have proper sanctions against the Russian Federation, and effective, and whatever waivers. There's so many waivers. Every time we turn around, we find out the sanctions are really just being subverted, and then sanctions on the regime in Tehran, and whatever influence you have in the administration, please, this needs to be real. We've had real sanctions in the past to deny them the capability to finance what is ultimately attacks on America.
I mean, the sanctions we have in place are unprecedented, but they're insufficient, as we've heard. And I think Roman's remarks were really critical. We have to go after enablers in addition to the direct perpetrators. And so looking for ways to protect against sanctions evasion is incredibly important. And my office doesn't really operate in that space, but we're very supportive of those efforts.
Well, whatever waivers there are, please, with your influence with the administration, they need to be reversed. I'm really grateful to recognize Senator Tom Tillis.
Thank you, Mr. Chairman. Madam Ambassador, thank you for your time. Your description of the 5 pathways was very helpful. I would appreciate it if any of that has been reduced to writing or a graphic, that I would like to get my office in possession of that information. Also, this panel has members of House and Senate Judiciary Committee. I was curious if you've had any specific interactions with Senate members, in my case, on specific actions that we should take to align U.S. law with some of our European partners. Are you aware of any initiatives now and members involved in it?
Yes, thank you so much for that question, Senator Tillis. Senator Durbin has, for more than a decade, been championing a crimes against humanity law. It's a very strong draft. It's deeply grounded in the existing U.S. legal framework. It essentially takes a number of crimes and makes them crimes against humanity when they're committed as part of a widespread or a systematic attack against a civilian population. So it just opens the jurisdictional doors to U.S. courts if a perpetrator is found here. So that statute may not be necessary to provide justice here in Ukraine because we can use our war crime statute because there's a conflict. But many times you see mass atrocities, for example, Venezuela, where there isn't a conflict and our war crime statute would not be active. That's where a crimes against humanity statute would be very important. My understanding from speaking with staffers and the senator himself is that he still lacks sufficient bipartisan support for that effort. And so whatever you can do with your colleagues in order to encourage them to, with fresh eyes, look at this proposal, and I think it would much better align ourselves with our allies.
Well, I think we should probably, as you know, if you follow any of the Judiciary Committee hearings, what we need to do is just tailor to sort of a minimal effort for maximal gain. So I'll be in touch with Chair Durbin on anything that we can do to help and maybe move something over to the House for consideration.
Terrific.
But, thank you all for being here. In the interest of time, I want to make sure that my colleagues are not cut short. I know that we have a hard stop, so I yield back, Mr. Chair.
Thank you so much. Thank you. Oh, hey, thank you, Senator Tillis, so much. And again, we appreciate your leadership in making this bicameral and now proof bipartisan, Republican, Democrat.
Thank you, Ambassador, for devoting your day to us and last evening, as well as your long career of dealing with war crimes around the world. I'd like you to just tell us a little more about U.S. support for the register of damage for Ukraine caused by the aggression of Russia, and how this might help long-term support for victims of this brutal war.
Yes, thank you so much for that question. It's really an exciting new initiative. There have been a handful of these claims commissions. You may remember back the Iraq's brutal invasion of Kuwait gave rise to a claims commission, likewise the war between Eritrea and Ethiopia. So there is some precedent here. This will be established at the Council of Europe. The United States has been able to place a very senior arbitrator, Lucy Reed from the Freshfields firm, as our member on the board. There's a number of other additional very experienced individuals who are used to working with civil redress and civil claims. They will be creating some sort of a framework to accept claims from individuals and entities across Ukraine who experienced tangible damage, not just financial damage to property, but also the loss of loved ones. They can register those claims, they will be verified and evaluated, and then they will be passed on, it is hoped, to an imagined claims commission, also to be established at the Council of Europe. That would have an adjudicative function that would, not at a full criminal justice standard, but basically ensure that those claims have been established and would recommend a reward. This is where legislation like REPO and these other creative thinking about how to gain access to Russian assets are going to be extremely important, because it will be illusory to be able to say to people, yes, your claim has been established, yes, here's a process to evaluate it, and yet not have a ready collection of funds to be able to satisfy those claims and execute upon those judgments. So whatever creative thinking can be done, and the State Department is very keen to have new authorities from Congress in order to be able to not just freeze assets, but ultimately put them to good use.
This would be at The Hague and under the auspices of the Council of Europe?
Yes, the Council of Europe, exactly, which is located in Strasbourg, France.
I see.
Yeah.
And how near are we to having that in place?
So the Register of Damage exists. They are starting to create a process. They're going to do as almost a pilot project, allow people to make claims for immovable property, and then they would expand to other forms of harm. The Claims Commission is still being negotiated and evaluated, but there seems to be a very strong commitment to set it up. So I'm confident that that second step will in fact come. But at the moment, they're establishing the ability of victims to register their claims and have those be evaluated by this new Register of Damage.
Well, I hope by the time that that's complete, that the resources will be there through the Repo Act, through the legislation I have on profits from sovereign assets to fund what needs to be done. You heard my query this morning to the Prosecutor General about your Atrocity Crimes Advisory Group and the important role that it plays. I assume you agree with him that to terminate U.S. funding for that now and the other activities we have, relatively small in dollar amounts compared to the large amounts necessary in terms of armaments to defeat the Russians, but that losing that funding would set back the efforts of prosecution and investigation of war crimes, including trying to get these kidnapped children returned.
It would be nothing short of devastating if we were not able to continue to fund the work of the Atrocity Crimes Advisory Group. And frankly, it would be embarrassing. This is a joint project with the UK and the EU. They have all committed to this project and committed for the long term. In addition, we've been able to establish a multinational fund that we're hoping individual states will contribute to, and we've had a number of expressions of interest across Europe and elsewhere to be able to contribute to the effort of supporting the work of the Prosecutor General as the main engine of justice for the war crimes and other atrocities committed in Ukraine. So this is a long-term commitment. You heard him say he has registered more than 100,000 potential prosecutable crimes. Those cannot all be brought to justice. It would be impossible. So he needs expert advice to help prioritize those crimes and to marshal the best evidence available to him to be able to seek justice, not only in his own courts, but then also to be able to support through the Joint Investigative Team, through the ICC partnership, anywhere else that may be able to assert justice. So we need to be able to maintain that commitment to justice in Ukraine, and that's why U.S. funding is critically important.
Thank you so much. Thank you, Mr. Chairman.
Thank you, Councilman Doggett. We now proceed to Congresswoman Victoria Sports.
Thank you, Mr. Chairman. I have a brief question for you related to war crimes related to prisoners of war, torturing and killing Ukrainian prisoners of war in violation of Geneva Convention. And there is, I think, Human Rights Commission did some reports and everything else. So you look at how there could be accountability, because the brutality, what it's done to Ukrainian prisoners of war is unbelievable. And I think that's something that Russia been known for, but they continue to get away with that. So I'm not sure if there is anything you do try to make sure that there is, that's going to be proper accountability can happen there too.
Absolutely, and I know that the Prosecutor General is very committed to that. Prisoners of war are entitled to humane treatment, full stop. And the testimony that we are hearing from some of those POWs who have been released is horrifying. The experience, not only the conditions of confinement, but physical violence, including sexual violence. And so that will be one of the core types of crimes that will be prosecuted by the Prosecutor General. And some of the experts that we have sent through the Atrocity Crimes Advisory Group came from the International Criminal Tribunal for the former Yugoslavia, where this was a central feature of the war crimes committed by Serbian and other perpetrators. And so individuals that did those cases at the Yugoslavia Tribunal are now advising Prosecutor Kostin's colleagues who will be doing those cases in domestic courts.
But is UN doing anything? They're doing all these reports, and I see, International Committee of Red Cross, everyone is doing all reporting. Is there any action taken to actually look into this issue and how to deal with that? Is there anything you involved or push to have more actions, not just resolutions and reports? Because this is a truly brutality that unbelievable that was happening there.
No, I couldn't agree more. It's critical that we not only document what happened, that we get those prisoner exchanges so that those individuals can be brought home, but that there must be justice, not only for the individual perpetrators who were responsible for holding and mistreating those individuals, but those up the chain of command that created a system of detention that allowed this to happen, that tolerated it, maybe gave orders for it to happen, but at a minimum acquiesced in it happening.
But you haven't seen anything happen at UN level beyond the reports?
No, I do know that the International Committee of the Red Cross is working very hard to assure humane treatment, but they do that in a very quiet and confidential way, so I don't have any insights into exactly what their
Right, but
approach
they're
has
not the one. They do kind of behind the scene
Right.
work. They're not the one who is going to be. We have this commission that's supposed, a variety of them, including one under UN, that issues some reports, but you haven't seen any actions beyond that. Is that correct?
No, not beyond that. I mean, I understand that the prosecutor of the International Criminal Court is also looking at custodial abuses, so that that investigation is ongoing.
Well, I
and-
think our funding also need to be tied to some actions because we need to go beyond just reports and presentations because we really need to start dealing with that issues. And that's frustration a lot of people in Congress, including dealing with UN, and not be very fond of actually giving more funding for them. And that's, something has to be addressed because this institution was set up maybe for different reasons, different times. They need to be either reformed or dissolved. Otherwise, we're wasting our money if we have to do alternative institutions. That's a lot of frustration, a lot of my colleagues, especially on my side of that. Thank you.
I'm with you. I want to see concrete accountability as well.
Thank you very much, Congresswoman Sparks. And actually, the perspective of the Congresswoman is phenomenally unique. Her great-grandfather served in the Red Army and disappeared. And so as she's talking about POWs and treatments by the Nazis, very likely, as she expresses concern today, how ironic and sad that what could be a great country, Russia, is now perpetrating its own abuses again, as previously done too. But what a perspective she has and what a treasured member she is of Congress and the tradition of Congressman Dr. Andy Harris.
Thank you very much, Mr. Chairman, and thank you, Madam Ambassador, for appearing here. You indicated at the beginning of your testimony that we kind of have a framework. I mean, we're not completely reinventing the wheel here. Now, with that being said, one of my concerns is that it's now 2 years into this conflict, 1 year and 11 months after realizing that a crime of aggression has occurred and that war crimes are being committed. But the initial, if you go back to the timeline of the initial tribunal, although there was, the Moscow Declaration in 1943, obviously Germany didn't surrender until May of 1945. And the first trial started in November. That's not a long period of time to have done the London Agreement, to establish the charter, to gather the evidence, to bring the indictment in October, and now to go to trial in November. So I've got to ask, and I appreciate, because I think your testimony was, well, you're having monthly meetings. Okay, when are we going to do it? When are we actually going to do what was done at the end of World War II, which is to believe that timeliness is important. And I think in this case, timeliness is exceedingly important because we have to create the record, again, in the court of public opinion, that Russia is committing war crimes on an ongoing basis, and as again, the testimony is literally on a daily basis. So what's the holdup? Why do we not have the same collective desire to proceed as we had in World War II?
Thank you. I do understand your frustration, and there are so many parallels with the current situation in Ukraine and the World War II period, but there are also some important differences. Number one, we had the full surrender of Germany. We had a number of key individuals, perpetrators, the top leader, except the few that managed to escape justice, in our custody. We had access to the territory. We had reams of documents, if you've seen some of that footage, where they would find documentation that showed the chain of command, who gave particular orders, who was in particular meetings. We had all that at our fingertips, and so prosecutors were able to work around the clock to put those cases together. We don't have that now. What we have, we're dependent upon open source investigations, insiders who are willing to provide information, survivors and victims who are testifying, experts who are able to give their best indication of what was happening and how the power works within the Kremlin. We also don't have custody of anyone of any consequence at present. As long as they stay within the territorial confines of Russia, they can escape justice because most of the institutions don't allow for in absentia trials. The ICC does not. Ukraine itself can prosecute individuals in absentia, but that is ultimately not satisfying. And so much of the delay is due to the fact that we don't have individuals in custody or sufficient evidence pulled together. Now, we can take comfort in the fact that the International Center for the Prosecution of Aggression has brought together prosecutors who have access to whatever evidence and information we do have. They're putting together dossiers, they're constructing the chain of command, they're putting together chronologies, what decisions were made by whom, what units went where, who was in charge of those units. They will pull together a group of, let's say, 12, 15, 20 key defendants. Aggression is ultimately a leadership crime, and so figuring out where to draw that line is one of the challenges that they're going to face. But those files will be ready once custody is obtained. And what I always say is that we are playing a very long game here. We may not have custody over anybody now, but over the years, somebody will travel, the political winds will change, there will be a transformation, they'll get tossed out, they'll want to save their skin, they don't want to fall out of a window or an airplane. They will travel to shop, whatever.
I understand that, Madam Ambassador, but when that person falls out of the airplane, there is no structure to bring something in. And the Prosecutor General, I think his testimony here today was that they have cases against people, they have successfully prosecuted people on war crimes. So why would you not want to create the international venue so that, again, when that person falls out of the airplane, the venue exists, the charter exists, how you're going to do this exists, and then begin to bring cases, because I find it hard to believe there's no case for which evidence is adequate, to start bringing the cases. I mean, again, to create this infrastructure. So I've got to ask, why isn't the infrastructure in place for when that occurs?
What I can say is that there is a serious commitment to do that. It is true that the lawyers are and I'm a lawyer, so although I'm a policymaker in this current role, I don't get to play that role. But
that might be my frustration. I'm not a lawyer.
Yeah.
Maybe that's why I don't understand that.
Some of the sticking points, I will say, there are some legal sticking points and there are some pragmatic sticking points. The legal sticking points are, for example, is the General Assembly empowered to create an institution with coercive powers? The Charter gives it only recommendatory powers. So that has pushed us into thinking about what other modalities might exist. You've heard mention of a number of states banding together, using a treaty modality, going forward under the Council of Europe, or creating a hybrid institution that's embedded within Ukraine's system with a lot of international investment, including by the United States and others. Those are what we're playing with. Some of these are satisfying some of what Ukraine wants to see. Some of them are satisfying what other states of the world want to see. The other issue is, frankly, the head of state immunity question. Are we creating an institution that can overcome head of state immunity? That's something that Ukraine cares deeply about, but there's also a legal norm against proceeding against sitting heads of state in national courts. And so we want to create something that has not only political legitimacy, but also legal legitimacy, and that will stand up the test of time.
One last final question. Who's empowered under our constitutional system to agree to that charter? Does it require Congress, or does the administration have the ability to agree, negotiate, and agree to the charter?
Part of that depends on whether or not it is a treaty modality. If we are asked to join a treaty, that would bounce to the Senate,
and
obviously.
what was it, after World War II, my understanding, it was not a treaty modality.
It was a treaty
right?
Amongst the victorious allies.
But did it require congressional approval?
I don't think that it's an excellent question. I'm revealing my ignorance here. Professor Safferling probably can answer this. I don't know that it was ratified by the Senate, ultimately, the Nuremberg Charter.
Thank you very much.
I can look into that, though.
Madam Ambassador.
Thank you very much, Congressman Harris. And indeed, as we conclude, it's just so inspiring. I want to thank our host, indeed, the International Nuremberg Principles Academy, Dr. Safferling. Thank you so much. And it's just inspiring to be here and to be in the presence of where the war criminals were tried, right here. And they were given a fair trial, except that they had committed such atrocities that they recorded themselves, that revealed the heinous conduct that ultimately led to their conviction. And then how incredible with Martin Bormann, in absentia he was tried. This is a message for the future. And so I'm just so grateful again for our host. I want to thank the staff of the Organization of Security and Cooperation in Europe from Washington and also Vienna. I am just so grateful to the Helsinki Commission, and then I'm just so grateful for the panelists that we've had. Each of them are inspiring, and as we want to encourage the people of Ukraine of their resolve and to show the German resolve, the American resolve, the resolve of Lithuania, just on and on. To see Western civilization incredibly come together and stay together. And then I also want to thank so much my colleagues. I am very happy to point out, bicameral, can you imagine? Something inconceivable, Senate and House working together. Bipartisan, again, we don't get any coverage on this, but Democrats and Republicans working together, because we're working together because we truly have deep affection for freedom and democracy, and we want that. And we want, hey, to deter future war, and a way to do that, as I've stated over and over again, is peace through strength. And I'm so grateful. I can't wait. I'll tell the whole story. On Friday, I'm going to be with President Trump. And I can't wait to let him know that Germany's reached its 2%. Not only did they reach the 2%, so did France. And so, but it's peace through strength, and then deterrence too, by having a legal system to go after war criminals in such a way as to deter them, and then the people who are actually conducting the atrocities, that they too will be identified with the new technologies we have today, and it should be a deterrence of future conflict in the future. And with this, again, I'm so grateful for everyone here. The lessons of Nuremberg, just to be in the presence here in courtroom 600, Nuremberg Courthouse, Nuremberg, Germany. God bless you all. Thank you.
May I quickly have a word of thank you myself? I want to thank Chairman Joe Wilson and the U.S. Helsinki Commission for coming to Nuremberg and holding this hearing here in our courtroom 600. And thanks to Janice and Stephen for helping us organizing this. And thank you all these distinguished guests and speakers that we had the pleasure and honor of hearing speak today. And let me also thank my team, in particular Evelyn and Kieran, who've been so strongly organizing this over the last month, and Anouk, Petra, and Frauke working from the back office. Thank you so much for making this possible today. Now, Courtroom 600 was the window to the world of the Nuremberg trial, but the entire Palace of Justice of Nuremberg, which was opened in 1916, and is indeed the largest Palace of Justice in Bavaria, served the trial, providing offices for some 2,000 staff, making this trial work. So do join the guided tour that we will have now on the Palace of Justice, which will start just outside this main entrance immediately after the group photo has been taken, which we're about to take now. So if those who have participated actively in this hearing, please step forward so we can take the photo. Thank you again for joining. Thank you for coming to Nuremberg and having this hearing here. I wish you a great time still in Nuremberg. I know some of you are unfortunate enough to have to stay on for some time because of some serious striking going on in Germany. Very unfortunate, I'm sorry. Have a great time in Nuremberg and safe travels home. Thank you.